welcome to this video in which I will talk about the Mühlleitner judgment of the European Court of Justice. My name is Carsten Thorn and I'm professor at Bucerius Law School in Hamburg. The Mühlleitner decision dates back to 2012 and gives reason to take a closer look at the development of jurisdiction over consumer contracts and its rationale. As we will see, consumer protection is one central component of European law, which has continuously evolved through the last decades, just like the European Law Academy, which I warmly congratulate on its 30th birthday with this video. Let us briefly go through the facts of the Mühlleitner case. Ms. Mühlleitner, domiciled in Austria, searched on the internet for a car of a German make, which she wished to acquire for her private use. After connecting to a German search platform, she entered the make and type of vehicle she wanted, thereby obtaining a list of vehicles corresponding to the characteristics specified. After selecting the car which corresponded best to her search criteria, she was directed to an offer from the defendants, the Yusufi brothers, who operate a motor vehicle retail business via Autohaus Yusufi, a partnership established in Hamburg. Wishing to obtain more information about the car offered on the search platform, Ms. Mühlleitner contacted the defendants using the telephone number stated on the website of Autohaus Yusufi, which included an international dialing code. As the vehicle in question was no longer available, she was offered another car, details of which were subsequently sent to her by email. She was also informed that her Austrian nationality would not prevent her from acquiring a car from defendants. Ms. Mühlleitner then went to Germany and, by a contract of sale signed in Hamburg, bought the car from Yusufi at a price of 11,500 euro, taking immediate delivery of it. On her return to Austria, Ms. Mühlleitner discovered that the car she had purchased was defective and consequently asked defendants to repair it. When defendants refused to do so, Ms. Mühlleitner brought proceedings in the court at her domicile, the regional court in Wels, Austria, for rescission of the sales contract, which she claims to have concluded as a consumer with an undertaking directing its commercial activities to Austria, a case falling within the scope of the consumer jurisdiction rules of the Brussels I regulation. The regional court dismissed the action, declaring that it lacked jurisdiction as the contract had been concluded at the business premises of the entrepreneur and not at a distance. This decision was confirmed by the Court of Appeal in Linz. On a further appeal by Ms. Mühlleitner, the Austrian Supreme Court then referred to the European Court of Justice the question of whether the application of the rules concerning the jurisdiction over consumer contracts presupposes that the contract between the consumer and the entrepreneur has been concluded at a distance. Before we turn to the court's answer to the question referred, let us briefly take a look at the rationale behind the specific provisions regarding jurisdiction over consumer contracts in international civil procedure law. The justifications for creating a special jurisdiction over consumer contracts are manifold, but in my opinion, they can be based on two main considerations. According to the model of the European legislator, consumers are typically the economically weaker and legally less experienced party. This also reflects the fact that consumers as one-time litigants usually go to court less frequently than entrepreneurs and do not have a corresponding wealth of experience. Thus, in the case of a foreign forum, it will often be more difficult for them to foresee the chances of success of a lawsuit. In addition, the consumer will regularly feel compelled to use a foreign lawyer in order to increase his chances of success. Uncertainty and high transaction costs may, however, discourage the consumer to bring an action at all, endangering his access to justice as a fundamental procedural right. The second reason can be found in the effective implementation of the consumer's protection by substantive law. European directives and their transpositions into member states' laws provide for most rules protecting consumers as structurally weaker parties to be mandatory. Mandatory means that the parties to a contract are bound by those provisions and they cannot derogate from by agreement. Thus, the contractual freedom of the parties, the so-called private autonomy, is restricted. As soon as a case has relations to more than one jurisdiction, however, consumer protection is at risk, as the general conflict of laws rules may lead to a legal system with a lower level of consumer protection. Hence, conflict of law rules have to be shaped in such way to safeguard the protection of the bigger party as provided for by substantive law. Consequently, Article 6, paragraph 2 of the Rome I regulation on the law applicable to contractual obligations contains a specific conflict of laws rule for consumer contracts, limiting the effects of a choice of law, while Article 6, paragraph 1, Rome I uses a connecting factor favoring the consumer. Nevertheless, one danger remains for the weaker party in an international case. In principle, conflict of laws rules are not unified, but differ from one jurisdiction to the other, the Europeanization of private international law being the main exception. Therefore, the form of a lawsuit decides which conflict of laws rules apply to the given case. To encounter the danger that a foreign court outside the EU deciding in a consumer case will not apply EU consumer protection rules, the law therefore must provide for a venue within the European Union where the courts will apply the Rome I regulation in order to determine the lex contractus. This can be demonstrated by the jurisdiction provisions of the Brussels I regulation. Articles 17 to 19 of the regulation establish a specific jurisdiction regime for consumer contracts, which aims at the protection of the consumer as a structural weaker party. By this, it is guaranteed that the consumer has always a venue within the EU at his disposal where he can sue the entrepreneur. Such court, in order to determine the applicable law, will apply Article 6 of the Rome I regulation, which will then lead to the application of the mandatory consumer protection provisions in force at the consumer's habitual residence. The entrepreneur, in turn, must sue the consumer at the domicile of the latter, with the same consequences as just described. The question remains under which conditions the consumer might benefit from such a forum actoris, and here the Mühlleitner decision comes into play. Let us now take a closer look at the ECJ's answer to the Austrian Supreme Court. I call to your mind once again that the Austrian Supreme Court referred to the ECJ as a question of whether Article 15, paragraph 1, literal C, Brussels I regulation, which is identical in wording to the current Article 17, Brussels I bis regulation, presupposes that the contract between the consumer and the entrepreneur has been concluded at a distance. The relevant part of the provision reads as follows. In matters relating to a contract concluded by a person, the consumer, for a purpose which cannot be regarded as being outside his trade or profession, jurisdiction shall be determined by this section if the contract has been concluded with a person who pursues commercial or professional activities in the member state of the consumer's domicile, or by any means directs such activity to that member state, and the contract falls within the scope of such activities. The criterion of directing activities, therefore, is of particular importance. It has already been subject to court rulings such as in Pammer-Altenhof. There, the ECJ has given a generously broad interpretation to the requirement of directing activities, especially in the context of the World Wide Web, thus considerably expanding the provision scope of application in favor of the consumer. The decisive part of the Pammer-Altenhof decision reads as follows. It should be ascertained whether, before the conclusion of any contract with the consumer, it is apparent from those websites and the trader's overall activity that the trader was envisaging doing business with consumers domiciled in the respective member state, in the sense that it was minded to conclude a contract with them. As possible indications for such willingness on behalf of the trader, the court listed, among others, the international nature of the activity, the use of a foreign language or a currency, the mention of a telephone number with an international code, and the mention of an international clientele. The mere accessibility of the trader's website in the member state in which the consumer is domiciled, however, being insufficient. Based on this, the Austrian Supreme Court in the Mühlleitner case considered the requirement to be fulfilled. Not only stated the trader's website a telephone number including an international dialing code, but during the following sales talks, the trader sent product information by mail to the Austrian consumer, and declared that her nationality was not impediment to the conclusion of a contract. Thus, there was a clear willingness on behalf of the trader to do business with a consumer domiciled in another member state. But why had the two lower courts then declined jurisdiction on the grounds that the contract had not been concluded at a distance? To answer this question, we need to take a closer look at the predecessor of the Brussels I regulation, namely the Brussels Convention on Jurisdiction and Enforcement of 1968, that for the first time contained comprehensive rules on the specific jurisdiction over consumer contracts in general through its revision in 1978. Its Article 13 provided for two distinct conditions, which had to be fulfilled in order to open up the territorial scope of application of the jurisdiction regime protecting consumers. While under litera A, the conclusion of the contract had to be preceded at least by an advertisement in the state of the consumer's domicile, a requirement maintained in the Brussels I regulation, litera B requires the consumer, in addition, to have taken all steps necessary for the conclusion of the contract in the state of his domicile. Thus, under Article 13 of the Brussels Convention, the contract had to be concluded at a distance. Its main rationale was that the consumer, who took all the steps necessary for the conclusion of the contract in his country of residence, might not be aware that he is leaving his own jurisdiction and therefore should be entitled to sue at home. On the other hand, the consumer who concluded the contract abroad was considered less in need of protection. As we can see, Article 13, Brussels I regulation, today Article 17, Brussels I bis regulation, no longer contains such a requirement. Nevertheless, some courts upheld this interpretation and applied these considerations also to the Brussels I regulation. This explains why the two lower courts declined jurisdiction on the grounds that the contract had not been concluded at a distance. However, the ECJ correctly answered the question referred by the Austrian Supreme Court in the negative, which seemed almost inevitable in view of the legislative history and the wording of the Brussels regulation. Furthermore, it should be observed that in the explanatory report accompanying the proposal for the Brussels I regulation, the European Commission considered that, I cite, the fact that the condition in old Article 13 of the Brussels Convention, that the consumer must have taken the necessary steps in his state, has been removed, means that Article 15, today Article 17, applies to contracts concluded in a state other than the consumer's domicile. It can be stated that consumer protection has thus evolved insofar as consumers who conclude the contract not at their domicile but abroad are nowadays also protected by the regime of jurisdiction over consumer contracts, provided that the entrepreneur prior to this had directed its activities to the consumer's country of residence. The former distinction between active and passive consumers does not exist anymore. Let us come to the end of this video with one final remark on the upcoming revision of the Brussels I bis regulation. What can we expect in the future in terms of legislative strengthening of consumer protection in international civil procedure law? In my opinion, one remaining major flaw is the exception for transport contracts in Article 17, paragraph 3, Brussels I bis regulation, which should be removed as it constitutes an unjustified privilege for some businesses. Currently, German courts are increasingly dealing with international jurisdiction agreements in transport contracts with consumers, declaring them invalid based on the directive on unfair terms in consumer contracts. The problem arises from the fact that Article 25, paragraph 4, Brussels I bis regulation only declares invalid those choice of court agreements that fall within the scope of application of Article 17, Brussels I bis. In this context, the legislator should provide more legal certainty and strengthen consumer protection in international civil procedure law, and therefore remove the exception in Article 17, paragraph 3, Brussels I bis, for the future. A potential collision with international conventions in the field of transport contracts is already prevented by Article 71, Brussels I bis. Thank you for your attention and goodbye.